The Second Amendment. Oh, we have the freedom to bear arms. Okay, the Founding Fathers were not perfect. You know they owned slaves, right? Also, the guns they were talking about were like muskets, not AR whatevers.
Was the Constitution written by imperfect people? Yes, but what do the sins of the Founding Fathers have to do with the Constitution and the principles themselves in today's present day? Now, did the Founding Fathers foresee civilians owning AR-15s? No. There's no way they could have seen that. The same way they didn't expect people to be exercising their First Amendment right through online speech. That's why they wrote arms, because they didn't know what kind of firearms we would be manufacturing in the future.
28 attorney generals have filed an amicus brief with the Supreme Court to overturn assault weapons and magazine bans. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like channel, like content, and what I do here, you can support me with the link. Everything is appreciated. And for my Connecticut residents, if you plan on getting your Connecticut pistol permit, please get that training done before July 1st, 2024. I'm going to go a step further and tell you to make sure that you get your paperwork submitted before July 1st, because then after that, it gets longer, harder, more expensive. And for those who have your permits, watch the expiration date. Don't let it expire. There's a link to the online renewal portal for the state of Connecticut in the description box. Let's talk about this. This is breaking actually today, March 23rd. The number of attorney generals who have now signed up for the amicus brief with the Supreme Court in the case of Beavis versus the city of Naperville, which is in Illinois, has grown to 28. What they're asking the Supreme Court to do is to approve an appeal for an injunction on Illinois' assault weapons ban, but where basically the Seventh Circuit said that the ban was constitutional and did not grant the injunction. All these attorney generals have jumped on board and filed a brief stating that the Supreme Court should take this up, which of course, once again, is going to set another landmark for every assault weapons ban case coming up the pipe. I'm going to bring you into here, give you some information, but attorney generals asked the Supreme Court to overturn AR and magazine bans. The Idaho Attorney General has joined the attorney generals of Indiana and 26 other states, AGs, or legislatures to file an amicus brief in the case of Beavis versus City of Naperville. On November 22nd, 2023, the Court of Appeals for the Seventh Circuit denied the petition for an injunction pending appeal to an en-banc review for or a writ of certiorari to the Supreme Court on December 20th. The request for an en-banc hearing is denied on March 8, 2024. A petition asking for a stay of proceedings pending a Supreme Court appeal is granted. That's very interesting. So the injunction at the lower court was basically just ignored. And these attorney generals went to the Supreme Court and said, no, we want you to look at this as far as the injunction goes to prevent the state from enforcing the ban. But the case focuses on whether the state of Illinois has the power to ban an entire class of semi-automatic firearms. And this is from the Idaho Attorney General. Attorney General Raul Labrador of Idaho and Todd Rokita of Indiana led 26 other states in filing a brief with the United States Supreme Court challenging Illinois' unconstitutional ban of AR-15 rifles and their standard 30-round magazines. Quote, this ruling from the Seventh Circuit flies in the face of the Bruin decision, which it does, and the Second Amendment's unqualified command, said Attorney General Labrador. To restrict an inanimate object based on nothing more than cosmetic appearance is absurd, and the Supreme Court needs to make this right with all expediency. The Seventh Circuit's decision in Barnett versus Raul found the Illinois gun ban constitutional, holding that the plain language of the Second Amendment and the terms arms does not apply to AR-15 because of their militaristic appearance. Now, how ignorant is that? When the Second Amendment was written, the musket was a military weapon and everybody had one. If you owned a firearm, you owned a firearm of the military of the time. That's why they didn't say muskets in the Second Amendment. They said arms, because they had the foresight to know that technology would change. I'd love to hear the Seventh Circuit's argument as to why an AR-15 is not included under the word arms. That's like saying a Volvo is not an automobile. But in fact, the arms in the Second Amendment originally protected were those in military combat. The Seventh Circuit's analysis bears no resemblance to the analysis prescribed by the Supreme Court of the United States. The brief asked the Supreme Court to grant certiorari and correct the Seventh Circuit's erroneous decision, arguing that even apart from having no basis in the text of the Second Amendment, the Second Circuit's artificial divide between militaristic firearms and firearms used for self-defense is indefensible. And this is a list of other states that are basically joined in. And as you can notice by this list, it's going right down ideological lines, which is fine. But this is just an interesting point that the overlap, the list of states that are involved in this is basically overlaps with states that have permitless carry. Like I said, it's an ideological line ideal. But I'm going to come down to here. Approximately 18 to 20 other state governments have different vision of the Constitution, including ours here in Connecticut. In this vision, the Constitution of 1787, Bill of Rights in 1791, is outdated, and you've heard them say this. You have heard them say this repeatedly. The interpretation of the Constitution should be by progressives who look to bend constitutional provisions to their understanding of what is best for the country based on the current situation. Okay, I'm going to go ahead and come out of that. So there it is. As I said, another landmark in the cases against assault weapons bans across the country. And they're pretty much putting the fire to the Supreme Court, and it's interesting to see what they're going to do. As you know, right now they're listening to the bump stock ban case as we speak. And I don't know, I doubt if they will take this up before their break, but there's always a possibility. They could put it on the docket. But this, once again, is just another step in a very, very long battle, and it's one we're going to have to fight. I applaud these attorney generals for jumping on board. And I'm saying that looking at what the Seventh Circuit had to say, they got it completely wrong. To say that, to say that an AR-15 is not covered under the word arms, that's creating a very dangerous ideal. Because you could say that, well, anything could be thrown into that mix and said, well, that doesn't fall under the definition of arms either. So they're painting themselves a very, very troubling scenario. But we'll see what goes forward with this. I applaud these attorney generals for getting on board. And like I said before, this is just another step in a long process. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.